According to the Centers for Disease Control, as many as 10,000 children are diagnosed with varying degrees of cerebral palsy each year. Several thousands of cases result from preventable medical malpractice. Can medical malpractice cause cerebral palsy? Absolutely yes. In fact, several thousands of cases result from preventable medical malpractice. Cerebral palsy is often caused due to brain injuries during delivery or birth complications such as lack of oxygen. Cerebral palsy is a serious, permanent, lifetime medical condition. There is no cure for it, and those affected will have it for the rest of their lives. That is why it is so critical for doctors to deliver babies properly and avoid injuries. Examples of cerebral palsy malpractice include failure to diagnose health problems. Pregnant women may have medical conditions, illnesses, or infections that doctors fail to diagnose that can cause their unborn baby to develop cerebral palsy. Injury during birth. Without proper care, a doctor can cut off a child's oxygen before, during, or shortly after birth, which can lead to cerebral palsy. Lack of treatment. Most babies are born with jaundice, a condition where the skin and eyes turn yellow because of a high level of bilirubin in the blood. If left untreated, jaundice can develop into a condition that causes brain damage. Other untreated illnesses like meningitis can also lead to cerebral palsy. Parents of children with cerebral palsy can expect to take on numerous unique responsibilities that have the potential to last for a lifetime. Raising a child with a disability takes time, effort, empathy, and a lot of patience. Those with cerebral palsy often face dramatic life changes. Approximately 20% of all CP cases result from brain damage that occurs during the birth process. As a result, the time spent in the delivery room represents a particularly delicate period in which even slight errors can have lifelong impact on the health of your baby. Under normal circumstances, the placenta continues to deliver oxygen to the baby until he or she is able to breathe independently outside of the womb. Doctors are responsible for safely delivering babies. They should know how to diagnose and treat health issues that can cause cerebral palsy. If a medical professional fails to perform their duties, then they will be held responsible if a child develops cerebral palsy. Here are some recent examples. In Maryland, a jury awards $229 million to a mother and daughter after the latter suffered a birth injury and developed cerebral palsy. In Tennessee, a teen was awarded $15 million by a federal judge for a brain injury suffered at birth which resulted in cerebral palsy. In Michigan, a family was awarded over $130 million after bringing a suit against Beaumont Hospital after their child developed cerebral palsy after his birth. In Guam, the U.S. government agreed to pay a Navy sailor whose child was born with cerebral palsy $11.5 million to settle allegations that a Navy doctor's malpractice caused the condition. In this insider-exclusive network TV special, Justice in America, Ayden Torrez's story, our news team is on location in Austin, Texas, meeting with Todd Kelly, partner at the Carlson Law Firm, to discuss the specific legal challenges and strategies in the medical malpractice case of Ayden Torrez against Dr. Jeff Hagen and St. David's Hospital in Bastrop, Texas. Todd has earned a reputation as an unyielding trial lawyer who repeatedly represents individuals and families against big companies and the Goliaths of the world, and repeatedly wins. He has earned the highest respect from citizens and lawyers alike as one of the best trial lawyers in Texas. Todd has built a substantial reputation nationwide by consistently winning cases other law firms have turned down. And his amazing courtroom skills and headline-grabbing success rate continue to provide his clients with the results they need and the results they deserve. This is the Insider Exclusive, live from Austin, Texas. It is my great pleasure to introduce Todd Kelly to the show. Welcome to the show, Todd.
Thank you, Steve. Good to be here.
Tell our audience a little bit about your firm. What specialty do you guys have?
Predominantly, we're a personal injury law firm at the Carlson Law Firm. We do handle some other areas of law. We have some family lawyers, we have some criminal lawyers, we do some bankruptcy. But by and large, we are a personal injury law firm, helping people who've been injured by the negligence or recklessness of others.
Right. There's many choices a lawyer can make to decide what their future might be in the world of the legal world. Why did you decide to represent the little guy?
You know, I fell into it almost by accident. I got out of the Marine Corps and really was just looking for a job, and frankly had interviewed with some defense firms I didn't know much about. The job offer that I got was with a plaintiff's personal injury law firm. And once I started working there and realizing the good that we could do and the way that we could help actual people rather than a corporation's bottom line, it sort of became part of who I was, and it got in my blood. And so,
and you're always fighting that, aren't you? The corporation wants to keep their bottom line high, right? And and they don't want to pay for be accountable for the injuries they cause individuals.
They absolutely do not want to pay, and you know, of course, the only way to hold them accountable is through money, and that's all we have in our civil justice system, is to make them pay financially for what they've done.
Todd, tell us about your client, Ayden Torrez.
Ayden is almost 10 years old now. He was born in September of 2012 at St. David's Hospital. He was a post-dates baby, meaning that he was after his 40th week of gestation. And unfortunately, neither the nurses picked up on it and the doctor, although he had redated him, didn't treat him as a post-dates baby. As a result, he suffered from what's called an anoxic brain injury, a brain injury as a result of a lack of oxygen during and around the time of his birth.
What happened after that?
Well, he was diagnosed with cerebral palsy, and cerebral palsy just simply means a paralysis of the brain, which affects his ability to walk, talk, think, and so he suffered a lifetime of injuries as a result of the negligence of this doctor and the failure of the nurses at St. David's to pick it up.
And that's a permanent lifetime injury, correct? It never gets better.
It never gets better, and it's significant from an economic standpoint. It's significant from a quality of life standpoint. You know, Ayden will not have the same quality of life as he should have had.
Right. A lot of these cerebral palsy cases result as a result of, let's say, medical malpractice of by the doctor. Okay, what did the doctor do wrong here, and who was the doctor at what hospital?
So it was Dr. Jeff Hagen. The hospital was St. David's. Dr. Hagen does not work for St. David's, but delivered the baby at St. David's. But what Dr. Hagen did, and it's an absolute no-no in the medical community, is that during the third trimester of Ayden's gestation, he redated the due date.
And what does that mean exactly?
So the due date would have been about 2 weeks before. I don't remember as we're talking the specific due date. It was about 2 weeks before Ayden was actually born. And the doctor actually did an ultrasound, and based upon the size of the baby, he said, no, I think the baby's going to be due 2 weeks later. Ultrasound is notoriously inaccurate for that, and even more so in the third trimester. But Dr. Hagen did it anyway and moved the due date back 2 weeks. That was absolute neglect, and I believe it was gross neglect on his part. And it was also negligent for the hospital not to pick up on that, since the original due date was in Ayden's record.
Right. Now, the Ayden now is about 10 years old. This is a case that, and bring this up, this is a case where 10 years after this happened, you're bringing this case. How does that work?
Well, this case was actually brought much earlier than that. We had because of a technical issue in the original filing, we had to non-suit the case, and we've refiled it just recently. But the parents actually came to see us within the first 2 years of Ayden's birth. And so we've actually had the case in our office close to 8 years now.
So there's some challenges in this type of case, isn't there?
There are significant challenges.
What are they?
For one thing, the lawyers who defend these cases frequently don't do anything except medical malpractice cases. They're very talented, they're very skilled. But more than that, there is a lot of money being thrown at these cases because the defense and the insurance industry understands just how much damage they've done, and they don't want to pay for it. It's an accountability issue. They would rather that this child go on Medicaid or Medicare for the rest of his life, and that burden be shifted to the American public rather than pay for what they broke and take care of him in a way that he deserves to be taken care of.
Now, originally in 2002, we talked about this before the show, the then governor, Rick Perry, signed into law Proposition 12, which put caps on some of these medical malpractice cases. Is there a cap on this type of case?
So the economic losses, those things, the medical bills, the future loss of earning potential and that sort of thing, those are not capped. Those have to be proven by experts, but those are not capped. But what is capped is the quality of life that Ayden has. So for the fact that this child will never live the life of a normal human being, a child or an adult, the fact that he'll see his friends play, or if he has friends, he'll see them play, he won't be able to join them. The fact that he will never, have any of the things that that at least I value most in life. And the cap for that, signed into law back in 2003, is $250,000. If that doesn't offend the conscience, I don't know what does. But I could easily get on my soapbox about how unfair the Chapter 74 caps are now. That's what it's currently called.
Right. Where are you in trial right now?
We don't. We literally just refiled this case within the past month. We had to non-suit the case. Because it had been more than 2 years, the parental claim was no longer valid, and so it is only Ayden's claim now. And as a result of that, we wanted to make sure that before we brought it back, we had everything that we wanted, all of our ducks in a row. And so we spent some time, did that, and now we basically are loaded for bear, and we refiled the case. And so we just started litigation again.
You will have to be able to prove, right? It's pretty obvious. We saw the video that we're showing on the screen that he suffers from, injury. That's not the difficulty in these type of cases. It's determining how much or how that can be compensated, correct?
Yes, that is difficult. Usually the 250 cap is not a problem because juries typically will award much more than 250 for the pain and the suffering and the mental anguish. There will be an argument over what the medical bills cost. As you might imagine, the defense is always able to hire an expert who will come in and say that our number is too high. They do it every time, which, kind of a side note, we stand up in courtrooms, we raise our right hand, and we swear to tell the truth, the whole truth, and nothing but the truth. But one of the whole truths that we never get to talk about is the fact that out of this money comes attorney's fees. Mm-hmm. Out of this money comes the hundreds of thousands of dollars it costs to get here. And then, all of those things. And then not only that, we're not allowed to talk about the fact that it's an insurance company who's created the problem and the delay through this whole thing. I really wish we could tell the whole truth in front of a jury.
Yeah, maybe someday you will, right? Tell our audience, because I think we talked about before the show, medical malpractice cases in the state of Texas are difficult to litigate these days because of the caps.
Well, because of the caps and the other restrictions that were placed upon medical malpractice under Chapter 74, which, create an expert reporting requirement, which has been absolutely just taken to the extreme since it was first initiated in 2003. Well, since it was first changed, I should say, in 2003. There's always been an expert report requirement. But when they changed it in 2003, they made it much more stringent. And even the case law continued to make it much more stringent to the point where I think it's almost one of those situations where the straw finally broke the camel's back, and they're starting to back off of that a little bit. And expert reports are now being a little more reasonable than they once were. But the expert report requirements are difficult. There are doctrines. There's the emergency medicine doctrine that has come into play. That really, there's a lot of restrictive things that prevent cases like this from even getting to a jury. So that when one does get to a jury, it's been through the ringer before it ever got there.
And I would guess that probably when people might suspect there's medical malpractice, a great majority of them don't do anything about it because they're comforted by their doctors. And you know the phrase, we did everything we could possible and that sort of thing. What does a person have to do before they come to a lawyer to try and get the information to find out if there wasn't the reasonable standard of care that should have been exercised by the medical professionals?
You know, the most important thing that you can do is get your medical records right away. As soon as you suspect something happened or something didn't happen that was supposed to, get your medical records. The number of times that I've been able to compare original medical records to the ones ultimately produced by the hospital to me when they know I'm involved. And when I compare those and see the differences, it's shocking.
What are the differences you mainly see?
Well, a lot of times, things that were never considered, or at least were not written down as having been considered in the original form of the records, suddenly there's a defensive posture. We considered, this option, we considered that option, or we tried this methodology, we tried that methodology, none of which shows up in the original version. Mm-hmm. But it's a defensive statement in the medical record that they produce in litigation, right. Which makes it difficult to get there. And a doctor with a white lab coat coming in front of a jury comes in with this aura of honesty and truth, and I'm here to help. And sometimes that's true. I mean, I see doctors too, but that white lab coat doesn't make it so. And doctors are human, and some of them lie.
I've done a lot of medical malpractice cases, and what I've seen time and again, whether it's in this industry or the law enforcement industry or whatever, they protect themselves. And oftentimes, a case or a doctor will not be, disciplined at all, won't even be brought up before the medical board, right? And that's sad, because there's plenty of doctors, I think, right? We want to weed out the bad ones. In fact, statistically, I think 3% of the doctors cause 1/3 of all the medical malpractice errors. I mean, we're talking about repeat offenders.
I was just going to say, many of the cases that I've had are about repeat offenders. My oldest daughter, when she was about 8 years old, was in school, and it was during the time frame when the medical malpractice reform was going on, and she came home to me and she asked me, "Daddy, why do you hate doctors?" And I had to take her aside and say, I don't hate doctors. Some of my best friends are doctors. But doctors aren't better than other people, and when they are negligent, they should pay. I hate the laws that protect doctors beyond that. Mm-hmm. It's not doctors. Doctors are just people. Some of them are great. Some of them are not.
One final question. You probably get a lot of calls from people who say maybe there was medical malpractice in the treatment of their loved ones. How do you decide which cases to take today?
Most of the time right now, because of the economic caps, the first place I look is, even if you're right, with the caps, given the damages that you have and the expense and the fees that have to come out of that, can I ever make it good for you? Can I ever make it right? And a lot of times, economically, the case is not feasible, and that probably weeds out more than 75% of the cases. Even when there was wrong, because of the caps and still by the law, I probably don't take, probably more than 75% of the ones that kind of get through the system to me. After that, it becomes an issue of, a lot of times, the defense will be, bad things just happen. And sometimes that actually is true. And so I have to dig into the medicine to find out, did a bad thing just happen? Or did the doctor or other healthcare provider do something to make that bad thing happen?
And of course, only you know whether this doctor's done the similar thing in the past, which probably should be an incentive, maybe in some cases, right? Which you can't bring into the court, but you know this.
Sometimes I know it right away, and sometimes I find out during the course of litigation. But yeah, I usually am not able to bring up the prior acts of that doctor. Every once in a while, I can find a way that it's relevant to the case that we're presenting.
This case is pending too, correct?
This case is pending.
All right. Well, good luck with it. Keep us posted, and thank you for being on the show.
Thank you, Steve. I appreciate you having me.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.